Continuing with one of our top stories of the day, the Constitutional Court ruling that President Ramaphosa did not mislead Parliament with his CR17 election campaign. For more clarity and reaction, we're joined now by Nthabiseng Dubazana, a legal analyst. Ms. Dubazana, very good afternoon to you. Perhaps let's break this down and discern what the meaning of today's ruling actually is.
So essentially what the Constitutional Court decided was, firstly, the matter, the public protector did not align herself with the preferred rules or parts of the legislation that allowed her to do an investigation into the CR17 campaign. So, and even when she did do so, she had also misled by saying that it amounted to what is this? Money laundering. So with the emails that she had access to, which Ramaphosa had already said that he did not grant her access to that, even with those emails, there is no connection between the money that was paid into CR17 campaign and also with the any personal benefits that he would have derived. Because remember, she did do interviews with the managers of CR17 in order to find if there's any connection between the monies that were donated to CR17 and any personal usage of the Ramaphosa himself. So now every finding that she had made and the remedial actions thereof are now set aside. So what also was set aside is the fact that the High Court that heard this matter before, which led to her appealing, was saying that every person has a right to question or defend themselves, the remedial action that is proposed by the public defender, and then as a result that's also upheld. But it's referred back to the High Court to deal with the other issues that the ConCourt has set out. But in essence, everything that she has found as a problem in terms of CR17 is now put aside.
I'd like us for a moment, Ms. Dubazana, to focus on perhaps the heart of the issue, which really is the Executive Members' Ethics Act.
Yes.
If the public protector is not the correct vehicle for such investigations, then is there an existing structure that allows South Africans to be able to investigate such issues and to be able to hold members of the executive to account if, in fact, as it has been found in this particular instance, doing so by the public protector is actually overreach?
Essentially, the Public Protector's Office is supposed to do that. They're given those powers by the Constitution itself, remember. So now, the way that the ConCourt has decided this issue gives the Office of the Public Protector sort of limited powers. Remember, in order for you to have such investigations happen, there has to be a complaint that was lodged. And as the High Court, in my opinion at least, correctly ruled and said that when he then lodged a complaint, it fell within the ambit of complaints for the Public Protector to investigate, right? So now at the situation that we're at per what the ConCourt has said, it means that now what are we supposed to do? I would assume we would be going to the NPA. That is the next best body to say, okay, I will be lodging a complaint and I'll be the complainant in this situation. These are the facts that come forth. But then the NPA will then have to conduct its own investigations through the SAPS in order to find all necessary information. But that too can also be challenged because now the NPA does not have that constitutional right to go so deep into such complaints because that is a Section 9 institution directive. So it will be very interesting to see which way we are now going to be forced to go. Are we still going to have to go through the public protector and see what happens, or is there going to be a different body that will now then be appointed to take over certain aspects of the public protector's office?
You've brought up some really pertinent points there, Ms. Dubazana. So what does this mean then, legally and procedurally, if the NPA doesn't have a constitutional mandate to investigate such? The public protector, when they or he or she does so, will be found to be overreaching their particular jurisdiction. Will there be a need for another body that will be able to do this, or would it be a situation of extending the mandate and the jurisdiction of one of the already existing bodies?
Most likely, there might be a situation whereby a new body might be created. However, if we're to look at the NPA, they could use this judgment today as precedent to say that we as the NPA have not exactly been given the powers to do so, but there is no other body right now, and therefore, as the prosecuting authority of the country, in essence, we can derive such powers, make a request, so to speak, or an application whereby we can use our powers to investigate and continue with complaints of this nature, as at this moment the Section 9 institution, in which is specifically the public protector, is not allowed to do so. That could be another way to deal with it, or the court, or specifically the ConCourt's or the president, will then infer certain powers that were belonging to the public protector and infer them into the prosecuting authority. So right now it is a very gray area and very interesting, I might add, to see which way we're going to go in terms of how are we going to deal with complaints of such a nature.
As the Office of the Public Protector put it, there is oftentimes a very fine line between a private and public interest. So it's really about finding that balancing act and the correct instruments of law to use for implication, or for application rather. What do you make, Mr. Dubazana, of the Chief Justice's standpoint, the fact that he actually is in agreement with the Public Protector?
Well, I think I liked what he said when he said that the line when it comes to the personal aspects of specifically Dr. Ramaphosa in this situation did not show anything in terms of him misleading Parliament. So, as you just correctly said, the line is extremely thin. But be that as it may, the Public Protector has to learn, so to speak, to differentiate between the two, which one is public and which one is private. Is it really in the public interest to go in this route, or is it now invading somebody's privacy and violating their Bill of Rights? So the court, in essence, is still saying, yes, you have these powers, you can do these things, we agree with you there, but learn to, reel it in a little bit and look at which parts of your investigation you're entitled to go to and deal specifically with all of that.
And I guess what's also quite key here is to look at the wording, whether or not the president willfully misled Parliament. So that becomes quite key. I see you nodding. Do you want to add on to that?
Intention is very important whenever you establish, let me speak on criminal liability. Intention is very important, because if the state can prove that you intentionally committed a crime, in essence, all the other elements, the unlawfulness and other things kind of fall into place. It's just a matter of factual findings that will lead the state to having a conclusive decision and conviction. So if he willfully had misled Parliament and said, no, in actual fact, this money didn't come to me in any manner or form, but it was found that it had, then it would be a different situation whereby perhaps criminal aspects, criminal case would have been opened against him. Intention is very key when you're dealing with such situations, because he vehemently denied that he derived any personal benefit from the CR17 campaign.
Why do you believe this ruling is seminal and important?
Sure, it's landmark, hey, because now at this stage we are, when it goes, depending how the High Court rules, because now it's being sent back to them to deal with, all the other aspects the court didn't deal with. But it's also saying that the public protector, it seems to have diminished the powers of the public protector as a result of perhaps maybe the person who's in office currently. Maybe when a new person comes in, things will be reviewed differently. I don't know. But right now, it has diminished capacity of that specific Section 9 institution, and it is now, the public begins to wonder, do we have confidence in us lodging our complaints there and them being dealt with in accordance, and we will get what we hope to get out of it? Because when you look at the history of what's happened since Mem Kwebane has been part of this institution, there's been a lot of losses and a lot of questions and all of these things. So now the public's interest in this, the public's confidence, in the Section 9 institution is diminished in every manner. But, for me, it's precedent setting that it has sort of limited the rights of the powers, of the public protector.
It's quite important that you mentioned that this is actually going to go back to the High Court, meaning that this is really not the end of this particular case. Highlight to us those areas or those aspects that have been sent back to the High Court for further evaluation and ventilation.
So the court says the ruling that was made that led to the appeal, that why is the word escaping me, Tammy? So the aspects of the findings that were made by the public protector, that the court feels that they should be reinvestigated and reopened, have to be reevaluated by the court. The court has to decide whether or not in the CR17 investigations, especially the paperwork, the bank statements and all of that can fall within the ambit, so to speak, of what the public protector could look at. Is it did she have those powers to go through all of that? So those are the issues that the court wants the High Court to deal with, and saying that right now it doesn't fall within the Constitutional Court's realm to deal with. Is it the constitutionality of those things are not in question right now? What is in question is whether or not the findings and the recommendations that were made were indeed within the ambit and the powers of the public protector.
Mr. Dubazana, we thank you for your time and your analysis this afternoon. That's Nthabiseng Dubazana, legal analyst on the Constitutional Court ruling against Public Protector Advocate Busisiwe Mkhwebane.